All right, guys. So the next part in the unit packet, if you're following along in the order we're going in, we're going to go through two Supreme Court cases here, and then the worksheet that goes with both of them. So we got Plessy versus Ferguson. We'll read through that, and I'll read through the Brown versus Board of Education. I'll kind of mark it up a little bit. If you want to do the same on your paper, that's fine. Just so we can understand what those two Supreme Court cases were about. And then after I do that, we'll go through the worksheet here on kind of cover them both. All right, because as we read through those statements, we have to identify if it was from the Plessy case or the Brown case. Okay, so both of these are what we call, you'll hear me say the term, and if you're reading through some of this stuff, you'll hear the term landmark Supreme Court cases. So when I say landmark case, it means it really played some large precedents in our country's history. Okay, and that's the other term we have to make sure we know too. I'm going to keep coming back to that word precedent, because remember, when the Supreme Court makes a decision, sets the precedent, it creates a situation where every state in the country and every courthouse in the entire country has to follow that decision. Okay, so what's cool about these two cases is it shows how our country evolves. All right, so we'll go through the first one. We'll obviously realize like that they were wrong in 1896 when Plessy versus Ferguson ruling comes out. They got it wrong. All right, and unfortunately, it takes until 1954 with the Brown versus Board of Education case to essentially reverse the original ruling. All right, but one of the things I want you to walk away with understanding is it's good that our system is designed in a way that it can reverse it. All right. If we get to a point where we look back at our history and they say, well, what we did then was wrong, we got to fix it now. Okay, and whether it's the amendment process or the process of the Supreme Court, those changes can take place, which is good. All right. So here's Plessy versus Ferguson, 1896. Hopefully you guys have, if at the very least, have heard about these two cases at some point in your schooling. You guys are all seniors, so if you haven't learned about these two cases in a history class at some point from grade school through junior high and high school, then I apologize. So make sure you're listening, because these are important cases to know because they're historical. All right. So it says you have heard the saying, some rules are meant to be broken. In 1890, a man by the name of Homer Plessy. So here's our main character, right? Our main person in playing this role. Broke the rules. The state of Louisiana had passed the Separate Car Act, which required railway companies to have separate but equal train cars. So that line, many of us probably remember that term tied to the civil rights movement. This idea that separate but equal, whether it was bathrooms and it was drinking fountains and schools, obviously, which will tie to the next court case. So separate but equal train cars for Black and white people. A person who sat in the wrong car had to pay $25 fine or go to jail for 20 days. You can probably guess the cars for Blacks weren't as nice as the cars for whites. Not only that, it seemed unfair to make Black people sit separately. A group of citizens called the Free People of Color in New Orleans formed a committee dedicated to repealing this law. They convinced Homer Plessy, who was 7/8 white and 1/8 Black, to test the law by sitting in a whites-only train car. When Plessy was asked to move, he refused and was arrested. All right, so there's, I guess, essentially the crime that eventually people, or Plessy and his group, fight, and it goes to the Supreme Court. Okay, so here's the argument. It says the Plessy argued that Louisiana's Separate Car Act violated the 14th Amendment to the U.S. Constitution. All right, so if you don't remember the 14th Amendment, guys, let's let me stop that share real quick and go to PowerPoint slides from a couple months, probably 2 months ago now. All right, so the 14th Amendment defines what it means to be a citizen and protects certain rights of the people. Included are citizen clause, due process, and equal protection. All right, so the piece that the Plessy case is going to be focusing on, it's not a citizenship thing, all right, because that's going to identify if you're a citizen or not. Due process is, okay, if you're accused of a crime, do you get a trial by jury, right to an attorney, that kind of stuff, okay? Equal protection is that the people of the United States, all the laws are applied equally, okay? So that's the piece of the 14th Amendment that Plessy and his group are going to argue and go to the Supreme Court with, saying this law that allows for train cars to be separate but equal, is that real equal protection of the law? Because they're not equal, all right? One train car is super nice, the other one's not very nice. Okay, so that's the piece that they're going to be arguing. It's the 14th Amendment, that section, I guess I should say, on the 14th Amendment. Okay, so let's go back to the case. It says that states may not deny any person within their jurisdiction equal protection of the laws. He argued, Plessy is he, all right, so Plessy argued that requiring black people to sit separately from white people implied that blacks were inferior to whites and therefore, we're going to use the word unequal. All right, so that's the real, I guess, meat of the argument. That is that equal protection under the 14th Amendment when one group's being treated differently than another group? Okay, so here again, if I should have started with this, guys, but make sure if you want to do this now, you can fill out the first page. All right. So the date of this case, so Plessy versus Ferguson, is 1896. And the amendment or right in question is the 14th Amendment. All right. All right, so that date's important, okay? And so, and one thing, and you've heard me say it before too, guys, in our class, and when we talk about some of these things that are obviously truly racist moments in our country's history. So when we talk about these things and we say, okay, look at the date, the context is key, all right? It's 1896. So this is still 20, 30 years after the Civil War, after the fight for slavery. Slavery has ended, and amendments have been put in place in the Constitution that were trying to give former slaves more rights and more freedoms within the system, or being treated equally in the system. So this was a way that within the city of New Orleans, they were trying to disregard that. Okay, so that's why it goes all the way to the Supreme Court, because the Supreme Court's got to make that decision essentially for the city of New Orleans and the people of New Orleans, right? But remember, this is focusing on Plessy versus Ferguson, so it's saying, okay, this could ultimately change what that law means in New Orleans. But if the precedents would ultimately say all cities, all states within the country would have to follow that suit. Okay, so that's why the decision is so important. So the Supreme Court disagreed. Okay, this is a moment in our history that not so good. It saw separate train cars as an issue of social equality, not political or legal equality. So the Supreme Court at that time in 1896 identified that the 14th Amendment was only referring to political and legal equality. So like the right to an attorney, right to a trial by jury, those types of things, okay? It wasn't referring to social equality as far as how you can be treated in society ultimately, all right, such as a train car. So it said separating the races did not take away from civil or political rights, right? Voting rights, stuff like that. You could still vote, but you had to drive on a separate car or train car to get to the place to vote. And that's what the Supreme Court of Judges was referring to. Justice Brown, who wrote for the court, saying that if one race be inferior to the other socially, the Constitution of the United States cannot put them upon the same plane. Justice Brown said that there had been separate schools for Black and white students for a long time, and many court cases had decided that states were allowed to have these segregated schools. Okay, so one of the major precedents of this case, and I'll probably say it again once I get to the bottom, is it almost legalizes segregation, because they're saying it's okay to have separate but equal train cars in this situation, right? So one of the 9 justices, Justice Harlan, was the only one, I'm going to highlight his name because he was the only one of the 9 to dissent, okay? If you don't know what that word dissent means, it means go against, all right? So 8 of the judges on the Supreme Court at that time in 1896 said, yes, we're okay with this. We're okay with segregation. We're okay with separate but equal, okay? Only one of them, Justice Harlan at the time, we can probably say he was ahead of his time, right? Because he said, not so fast. I don't think this is right. Okay, so he dissented in the argument. He wrote that our Constitution is colorblind. In other words, it shouldn't see color in any situation, whether it's, going back to this term, it's political, it's legal equality, or social equality. All right. That's what Justice Harlan's saying. That's what he is meaning, or what I guess he's saying by saying the Constitution is colorblind. It doesn't see in color, okay, and does not tolerate classes among citizens. He said the court's decision would lead to, look at this, like he predicts the future, lead to racial hatred and increased attacks against Black Bills' rights. So from 1896 all the way until the civil rights movements in the 1950s and 60s, you saw an increase in segregation, an increase in separating, and the idea of separate but equal when it comes to schools and it comes to other locations and facilities and stuff. All right. So what? So here's more of the precedence piece. So the court's decision set the stage for many years of discrimination against people of color. Plessy's case gave rise to a new doctrine of separate but equal. States were free to pass laws that kept races separate, and although the facilities were supposed to be equal, they rarely were. The separate but equal doctrine would not be abolished until the Civil Rights Act of 1964. All right, so again, I keep coming back to the idea of precedent, okay, and why we have to understand what the word precedent means when it comes to the Supreme Court, because when they make a decision and they set the precedent, it allows for the whole country to act in a certain way based on that decision. So back in 1896, when this Supreme Court okayed separate but equal, ultimately legalizing segregation, ultimately legalizing discrimination, all right, it sets our country back for 96 to 64. So we're talking 60 years, 50, 60 years between the next case and the Civil Rights Act of 1964. Okay, so I mean, this is one of those cases where if you think back and say, oh man, if that Justice Harlan, if there's more Harlans on that Supreme Court, and they dissented on this case and said separate but equal is not right, is not legal back in 1896, our civil rights movement of the 1950s and 60s would have been happening in possibly in the early 1900s instead. Would have been a game changer. Okay, so let's go on to the next case then. So kind of piggybacking off this one, like I said, we'll come back to that worksheet that goes off of both. All right, so again, just make sure you fill out I can go to it right now, to the Word document, or your hard copy in the packet. All right, so Plessy versus Ferguson case. What was the issue involved with this case? The issue was whether or not Plessy and Blacks in general should be required to ride in separate train cars. That was what that case was about. And explain the Supreme Court ruling and the precedent that this case created. And ultimately, the precedence was created that this case allowed for separate but equal. It allowed for segregation and discrimination to take place legally in the country. Okay, so that's the precedence that was set. Okay, and at any time, guys, I know I'm going to keep rolling here, so if you need to pause while you fill out some stuff in the worksheet in the unit packet, that's fine. Just pause it, fill out what you need to pause or fill out, and then go ahead and play again. Okay. All right, so let's look at the Brown versus Board of Education case now. So we're looking at about 50 years later. All right, so 1954. So from 1896 to 1954, we got a new case here. So Brown versus Board of Education. So in 1950 and 1951, change the highlighter so I can. Black parents and students in several states got tired of laws that required children of color to attend separate schools from white children. All right, so there's your idea of separate but equal, right? The segregation piece. So again, 1954, that's the precedence. All right, that the Plessy versus Ferguson case set the precedent that it's okay to have segregation. Okay, so all the way up until 1954, that's taken place. For decades, many states had kept blacks and whites segregated, or separated from each other based on their race. In 1896, in the case called Plessy versus Ferguson, the Supreme Court had said this segregation was constitutional as long, all right, as the separate facilities for blacks and whites were equal. Well, we obviously know that that wasn't the case. Okay. In some places, schools for black children were run down and lacked things like gyms or cafeterias. In many places, there were school buses for whites, but not for blacks. Parents had to send their kids across town to school when there were schools right in their own neighborhoods, but the closer schools were whites only. With the help of the National Association of Advancement of Colored People, that's what the NAACP, which is around today, parents and students decided to challenge the Plessy decision. Okay, so this is what's, I'm going to highlight this. Parents and students decided to challenge the Plessy decision. So think about that real quick. Why that's so important to understand that statement there is that our system can change. Remember, we talked about our Constitution way back when we first started covering it. We said it's a flexible Constitution. I gave you guys the political cartoon of the two trees. One was a palm tree that was bending in the storm. One was a rigid oak tree that was just snapping and breaking in the storm. Okay, and that's what we talk about. We want our Constitution to be that palm tree. All right, because when the national crisis or the storms attack, a tree can bend. All right, it can adapt, and then once the storm's over, it pops up. All right, our Constitution can withstand it and can get through it. And this is just another example of that we can have the Supreme Court make a decision back in 1896, and then now in 1954 with this one, they're gonna challenge it. They're gonna say we think they got it wrong back then. All right, and we want to see what this current Supreme Court of 9 judges thinks. Okay. So in Topeka, Kansas, Oliver Brown and several other parents tried to enroll their children in the closer whites-only schools. They were rejected. In other states, people's efforts to get better facilities for black schools were ignored. So their argument was, Brown and the others argued that segregated public schools are not equal and cannot be made equal because keeping black and white students separate sends a message that black students are inferior. Therefore, the very act of separating black and white students violates, or back to the 14th Amendment, the US Constitution, which guarantees equal protection of the laws. Okay, so now think about this real quick. Let's flip back over to the Plessy versus Ferguson. All right, so in that Supreme Court decision, they were talking about social equality, not political or legal equality. So when it comes to education, is that different? All right, and that's kind of what they're arguing. They're saying, well, wait a minute, you are okaying people to be segregated when it comes to socially, all right, in public, on a bus or a train car, all right. But what about in a school where education is a necessity to be successful in life? Okay, so that's what their argument of this group with Brown was arguing. Like, I think we got more of a case here, right? Because this does violate our rights under the law. All right, the decision is this: the Supreme Court agreed this time. Okay, in a complete reversal from its decision in the Plessy case, the court said that separate but equal doctrine has no place in public education. Separating children just because of race generates a feeling of inferiority as to their status in the community and may affect their hearts and minds in a way unlikely ever to be undone. Segregation therefore deprived black students of equal protection of the laws under the 14th Amendment. Okay. All right. So there's the new decision. So what? So here's our precedent. The court's decision rejected separate but equal doctrine. All right. That had approved 58 years earlier in the Plessy versus Ferguson. Now, all white schools could no longer reject black students. Although the court's decision was aimed at K through 12 public schools, the decision was also applied to colleges and universities. But not everyone was happy with the decision in Brown. In 1963, Alabama Governor George Wallace spoke out against letting black students attend the University of Alabama. He stood in the doorway to block 2 black students from being able to register. The conflict ended when President Kennedy ordered the Alabama National Guard to the scene. So that became a a whole different news story years after this Brown versus Board of Education case is finalized. Okay. All right. So let's go to the first part of the worksheet. So make sure you're getting this filled in as well. So the date of the Brown versus Board of Education case. All right. We're looking at 1954. The amendment or right in question, we got the 14th Amendment again. And the issue involved with this case is identifying whether or not segregating schools was a violation of the 14th Amendment. All right. So, in Plessy versus Ferguson, they said it's okay to socially segregate or segregate people socially, when it comes to train cars or restaurants and stuff like that. But this case is looking at it from that perspective of schools. All right. Is that fair? Okay. And then explain the Supreme Court's ruling and precedents that was created. So the Supreme Court ruled in favor of Brown, saying that segregating within schools is a violation of the 14th Amendment. Okay, and then the precedence that sets is it starts ending the separate but equal policies, saying that that's not allowed. Separate but equal is no longer allowed. All right, but it still takes a few more years. So this is 1954. It takes until 1960s for the Civil Rights Act to essentially abolish all segregation. All right, but this was the start of it. So this at least was getting rid of segregation in the schools. Okay. All right, so let's go to the worksheet then that goes with that. All right, so for this one, let's go. It says a long time coming. It took 58 years for the Supreme Court to finally reject the idea of separate but equal. In 1954, the court rejected this doctrine in a case called Brown versus Board of Education of Topeka, in which parents fought against separate but equal schools. It says, how did the court's reasoning change? Read the following statements and decide whether they are from the Plessy decision supporting separate but equal or the Brown decision rejecting separate but equal. Okay, so as we read through these, we're just identifying it's Plessy if it's supporting separate but equal, then we'll put BR for Brown if it's rejecting separate but equal. Okay. All right, so number one, scroll this up a little bit. All right, number one says the 14th Amendment could not have intended to abolish differences based on color. So it says it could not, all right, have been intended. So this would be referring to the Plessy case. Number two, the impact of separating people just because of race is even bigger when the law says it's okay. All right, so this will be part of the Brown versus Board of Education case. All right, so it's one thing, to separate people, but when the laws are saying, like the Plessy versus Ferguson Supreme Court case ultimately okayed laws to say it's okay to separate people, right? And that's why the Brown case was so important, because it's finally realized, that's not good. Number three, laws that allow or require the races to be separate do not necessarily imply that one race is inferior, right? So that would be more the Plessy case saying that. Brown's going to say, no, it does. When you separate groups and one group's not getting as nice of stuff, you are saying one group's more inferior. All right, number four, just because racial segregation existed when the 14th Amendment was adopted in 1868 doesn't mean it's constitutional. So another example from the Brown case. And again, there's that flexibility of our country. Just because we were racially segregated in the past, all right, doesn't mean we can't change, or that doesn't mean it automatically makes it constitutional to do those types of actions just because it's happened in the past. Number 5, separate educational facilities are naturally unequal. So saying that having separate places for education is unequal, one of the main points of the Brown case. Number 6, state governments have the power to decide whether to keep races separate. So case that identified that it's okay to separate people by race was the Plessy case, and ultimately told the states it's up to you if you want to or not. Number 7, children and adults can be treated differently under the law. So equality under law doesn't mean blacks and whites must be treated exactly the same. All right, so again, that statement saying it's okay to treat people differently. That would be the Plessy case as well. Number 8, making facilities equal isn't enough as long as blacks and whites are still separated. So that'd be the Brown case. It's supposed to be are still separated, not are still are separated. Number 9, the 14th Amendment could not have been intended to force the two races to mingle together when they don't want to. All right, so it's not saying anything that's the whole purpose of the 14th Amendment, is saying that we can't force people to be separate, but the Plessy case is our answer here, because they're also implying like the opposite, like you're forcing people to communicate even if they don't want to. No, that's up to you and I who wants to interact and mingle, but we can't have laws that say you can't. Number 10, research shows that separating white and black children just because of their race makes black children feel like they are inferior. So that was our Brown versus Board of Education case that said that. Plessy's the case that says, no, it's not going to make them feel that way or look at it that way. Number 11, if requiring blacks and whites to be separate suggests that blacks are inferior, it is only because black people choose to see it that way. Another example of the Plessy case. Number 12, laws cannot change social prejudices. The Plessy case as well, because remember with the Plessy case, they focused on saying it was okay to have social segregation. Oh, so we got a cat fight going down here. Number 13, blacks and whites can only have equality by appreciating each other and choosing to be together. That would be our Plessy case as well. And the last one, number 14, separating the races in school makes them unequal under the law and violates the 14th Amendment. So there's our Brown versus Board of Education again. That is essentially the, I guess they don't like each other. So that's Brown versus Board of Education as well. Separating the races in school makes them unequal under the law. Okay. So what you can do, guys, is that last piece, just read through those 2 bullet points and answer the bullet point yes or no, and then write your own little answer there. But that'll be kind of more your opinion on that piece. So I'm not going to answer that one for you. Okay. So we should have that fully done. I just read through Brown versus Board. I read through Plessy versus Ferguson. We just went through the worksheet, and then you should also have the page with this information filled out as well. Okay. So that's the 2 of the landmark cases we're going to cover. The next section will be, you guys are going to be reading through a handful of cases on your own, and then I'll go over a few of them to make sure that we understand the cases, but it's going to be kind of come down to whether or not you have some questions for me or not. Okay, so if you do have questions, again, don't hesitate to send me an email or a message on Remind. Okay.